Is there anything on the 28th?
I'm checking. I don't believe so, but I'm just going to double check. No. There's nothing between the defendant and the victim. All the victim does, or the defendant does, is check his voicemail on the 20th.
So it starts on the 29th?
Yes.
All right, what's the position of the defense?
No objection.
All right, that'll be received without objection. Text message between the victim and the defendant on October 8, 2017, resuming on December 7, 2017, regarding paying tickets on the car.
Correct. One moment.
Are we talking about parking tickets?
So, on October 17th, if I can just go to the specific text message.
What's the position of the defense on it?
Is hearsay. And I don't know that it's relevant.
Well, I would find that it's not hearsay, but I don't believe it's relevant, so let me find out.
You would find it was not hearsay based on what?
There are communications between the defendant and the victim. The defendant's statements are statements of a party opponent. The victim's statements in return are placed into context to show what the defendant is talking about. But how is paying a traffic ticket relevant in October of 2017? Or a parking ticket?
On October 18th, I'm sorry, it should be 18th, not 17th. On October 18th, 2017 at 3:57 p.m., Scandirito sends the defendant a text that reads, "More tickets came here yesterday. You have 1 month to clean them up or the car is going to be sold." The defendant says to the victim, "The Sun Pass tickets?" Question mark. The victim says, "Yes, a few more totaling $490 and also Miami-Dade." The defendant says, "Okay, it's the same one. I requested they eliminate the penalties and I am waiting for that." Then, going further to 12:17.
You mean 12:07 or 12:17?
Sorry, 12:7. Sorry, I'm switching between. They have further conversation about paying the same Sun Pass tickets. The defendant requested his, I'm trying to get to it specifically. The defendant requested his father send him a photograph of the debt collector letter that the father received because the Sun Pass ticket is not paid. The father sends a photograph of a Sun Pass debt collector. This is a debt in the amount of $107. The defendant then indicates that he has paid it, and he sends a photograph proving that the debt has been paid online. And this is the vehicle, the Prius that the father owns.
Is it the government's position that the photograph that the defendant sent back is fraudulent? Did he pay actually the Sun Pass debt?
No, he did pay the debt.
Okay, all right. All right, I find that it's irrelevant. I'm going to sustain the defendant's objection to that line of communications, especially since the defendant did pay the debt. All right, next.
Your Honor, the state's position is also that given the financial relationship between the defendant and the victim is at issue in this case, this indicates that the victim is willing to sell the defendant's vehicle if the defendant doesn't pay the debt, showing that there is a financial tension between the two. So in that aspect, it's highly relevant because this is less than 6 months from the date of death.
Okay, fine. I've made my ruling, Mr. Parnfield. I appreciate your argument. I'm sustaining the defendant's objection. Text message on December 13th where the victim tells the defendant to bring money, buckets, and the car. And the defendant says, okay. What's that about?
It is the victim, again, requesting that the defendant pay him some amount of money and the defendant agreeing that he owes the victim $400.
The defendant agreeing that he owes the victim $400 for what? What's that about?
There's no context to that exchange.
Well, later there's a $400 deposit.
That's the second time. That's on March 12th. That's
Different $400.
I believe so.
Position of the defense.
Does the state even have an idea what this is about?
Well, what it's about is a debt.
Well, it's not a debt. Butkus is not a debt.
I don't know what Butkus is.
Right, well, I'm telling you it's not. Okay, and so if the state doesn't have evidence that it's a debt...
Well, the way that the email reads is it is a debt.
But it's not. It's a football league, so it's a betting ring.
But Butkus was the linebacker for the Chicago Bears.
It's not a debt. So, I mean, the state doesn't have any evidence of that. I mean, so are we just going to admit any conversation?
No,
between
I just
the-
sustained one of your objections, okay? So this one, you're telling me, has nothing to do with the debt.
No.
And the state's position is, well, it has to do with money that the defendant owes to get involved in something.
The defendant owes, the victim is telling the defendant to bring money to him, and the defendant says, okay.
Okay. Sustain the objection. All right, thank you. There's no evidence that the victim, that the defendant didn't bring the money. There's no evidence of an outstanding debt on this amount. There's no, it's too tangential. Again, I'm not sustaining a hearsay objection, but I just find it's irrelevant. Sustain. Next one, March 12th. Victim tells the defendant to bring $400 on Sunday. The defendant says yes. And defendant to victim, I deposit $400 into your Chase account. I'm in for golf if there is a spot. Position of the defense.
It's completely irrelevant. I mean, he was paying a regularly prescribed payment to his father.
All right, thank you. I'm going to overrule the defendant's objection to this. I find this is relevant. Given the closeness in time to the disappearance of the victim, and it does discuss money that is due and owing between the victim
And paid, just so we're clear.
Well-
And paid. It says I deposited the money. And
different things. Bring $400 Sunday. The defendant says yes, and then the email further says that the father deposited money into the guy's account. So it also shows
The defendant,
he deposited the money for the car. That's the regularly scheduled car payment.
the defendant is saying I deposited $400
Yes.
into your Chase. I am in for golf if there is a spot.
correct.
So tell me about that debt.
It shows that he's indebted to the father for the car. He has the debt for the car.
What did he say in his statement about the car? He said that I was given the car upon the death of my mom, correct? Does he acknowledge a debt due and owing on the car there that he is?
Not the law enforcement, he doesn't.
No, I'm talking about, that's the only other evidence there is about the relationship about the car.
Correct.
All right, I'm going to overrule the defendant's objection. I'm going to admit that. That show the defendant, okay, I'm admitting that. Missed calls from landlord Shear, position of the defense.
Hearsay
Thank you.
and irrelevant.
I find them to be relevant, and I'm overruling the hearsay objection. It's not
I don't
hearsay.
even know who Landlord Shear is.
Well, we have emails that tell us who landlord Shear is.
We have emails that purport to say
Thank
that,
you.
but if we don't accept them,
Thank you. I've overruled your objection. I'm admitting those. Screenshots defense took from the WhatsApp device from March 28th. I assume that had to do with our Friday right before trial when you said you wanted to get the WhatsApp device and to look at it. So now they want the photographs of that last minute stuff. What does it show?
It shows a conversation with the female whom he is having a voice note from the 27th, which are the additional screenshots that we're seeking to admit, to both contextualize the relationship and to show that she's continuously asking him for money and he's continuously offering to give her money the day before the homicide.
Okay, but so the screenshots of the same conversation from March 27th.
what are the conversations on the 27th?
Well, I think I think when we're talking about the CD.
Yes, but this is so the CD is a voice note. Basically, he records something and sends it in the course of sending text message conversations. This is the context of the text message conversations, at least for the 27th. I didn't go back to the 25th. I just went back to the 27th.
Right. Well, okay. And 119A and B, 120A and B, and 121.
Are the call recordings?
Are those the ones on the CD?
Yes.
And what did I rule on those tentatively?
You admitted those.
All right. All right. Well, I tentatively.
No, those are ones that you admitted because those are the recordings of the phone calls to the friends and family.
Okay. All right. So those are admitted already. All right. 126C and D and 127 are the ones I provisionally admitted.
Correct.
I am now going to admit over the defendant's specified objection, 126C, D, and 127. I find that they're relevant and probative of the defendant discussing with another person, a female, his financial wherewithal to provide for that person, and they occur prior to the death of the deceased. So I'm admitting 126C, D, and 127. So let's now go back to the screenshots.
I can provide them to Your Honor.
Do the screenshots cover those calls that I've admitted and more?
No, not the calls. The screenshots are,
Okay.
screenshots do cover WhatsApp voice note, Stacy did at number 127.
Okay.
And then it's the text that Ms. Ramsey spoke about in her opening.
Can we take a break and give you guys a break for the bathroom? You'll hand me the screenshots. I'll look at them. Is your next witness going to be required for the screenshots?
No.
So our next break, I will cover the screenshots.
And then I didn't put it on there, but I would also ask that the witness be allowed to testify that he searched for Colfax, which is the company that the defendant ostensibly worked for a period of time, and then the last time that there was any communication with anyone from Colfax was on March 19th of 2018.
I don't understand. This is all coming from, what's the source of that negative testimony?
The phone. So a search, you can search the phone for keywords. Colfax.
It's the phone, the Samsung phone.
Yes, sir.
So you search the Samsung phone for all these things that we have, and then the negative search is Colfax, which is the company that the defendant indicated he worked for.
Correct.
And the last date of a communication with Colfax is March
19th.
Okay, is there objection to that?
I mean, that really is hearsay. I don't even know who Colfax is.
Well, the defendant identified Colfax as his employer when he was doing, I think, the real estate work.
No, he said he was a consultant, he was self-employed.
Right. What did he say Colfax was his employer?
Colfax was his employer, and we will be introducing his employment records from
In
Colfax.
March of 2018?
He was employed by Colfax in 2017. His hours were reduced to part-time in December of 2017 with a 3-month trial period, which would end on or around March 27, 2018. So the purpose of the testimony is to show that the last time he communicated with anybody where he was consulting was March 19, 2018.
Who's testifying to this?
Well, it's coming from the phone,
No,
the
but who's
Samsung.
testifying to this whole story about he had a 3-month trial, he got
I don't
part-time?
know. Listen,
They're the business records.
business records of Colfax, I guess. I don't know.
Business records that say he had a 3-month trial, that was.
I don't know. I didn't look at the business records you have, I'm sure, but I don't know. All right, I'm admitting that over the defendant's specified objection. I find this relevant. We'll take a 5-minute break for you all to use the restroom. Mr. Scandirito, do you need to use the restroom?
Yes, please.
All right, we'll take you down 5 minutes. Let me have the screenshots from the 27th and 28th.
The 28th, Ms. Ramsey still has the 27th.
The 28th, okay, I'll look at those. And then,
This is the first time we've seen these for the 27th.
So you saw that before I saw that. You
No.
looked at the phone.
all right, let's take a break, guys. Bathroom. You could use the Scandirito. Take them down for the
You
bathroom.
never looked at these, you never gave these to me. We gave you the screenshots we took from the 28th only.
And then the phone was on the screenshots from the phone.
But you've never given these to me.
To go from Nestler Paleto to MMD Realty to Mackin Realty to finally Colfax. So it would be incomplete to not include, and I don't see the prejudice to the defense of including earnings if he's earning a good living at that point in time.
I thought that's what you established from 2013 through 2017.
Yes and no, but there's also city national records of the landlord of Diana Shear that
He's a
has.
50-year-old guy. We could go back, just like our Social Security records go back to the first job you've ever had. Technically speaking, you could probably go back to the first job he ever had. I am ruling that anything prior to 2013 is irrelevant. It is irrelevant. I'm allowing you, based on your argument to me, to include 2013 through 2018 to show a standard of living that he had grown accustomed to from 2013 through 2015 and 16, and then a drop-off of that income to where he is now offering Lyft rides and earning money through Lyft. I got that. I'm allowing you to do that, but I'm not going to let you go back to 2011. I think that's just too remote. All right, what else is there?
There are city national records of the landlord of Diana Shear that have a business record certification attached to them. Within those,
Let her finish. Go ahead. The records of the apartment.
correct. So in addition to
How long are those records?
from when the defendant begins to work, begins to live in that apartment,
Which is when?
which is in 2016.
Okay. And it shows that he religiously paid his rent, probably
He
for.
didn't pay that girl. I mean, that's why we have landlord Shearer, Dr. Henry Shearer.
They own it together, and the Avenue Lost condo records, which is states 146, also has a business record certificate, and they are the records that show what his actual lease agreement is and who it's with. So you can see the exact amount of the defendant's rent, and only the defendant's rent, being entered into Diana Shearer's account. It starts off as $2,750, and then in December of 2017, several months before the murder, it goes up to $2,800. So we
Like
can
rents
show
do. They don't go down. They usually go up.
Correct.
But let me ask you this, okay? So you want to establish that he paid rent on a regular basis from an account that is presumably his, correct?
Well, sure.
Is he paying in cash?
Yes,
Okay, all right. I think the defense wants to show that he's paying in cash.
that's correct.
Judge, I'm objecting to these records because we did not have discussions about admitting bank records and things like this that are wholly unconnected to the defendant or to the decedent.
These are, what we're talking about right now is the records of his rental
Landlord,
payments.
that is literally hearsay.
Yeah, but okay. So the documents themselves, you have stipulated to their authenticity.
No, I don't believe that we had any discussions about bank records or anything like that that belong to someone other than the defendant or the decedent.
Well, I don't know what the stipulation says. I don't know what
We have something that's in there. Well, I regret that because, I mean, that was not the intention. I met with Mr. Parnasiello in his office, as did Mr. Arkansas. We talked about stuff. We put things down. I don't know when these records were provided to us, but I'm certainly not stipulating to the authenticity of something that's not connected to my client or the decedent.
It is connected to your client. It is your
Without-
client's apartment rental records.
But these are not transactions
No, those
going from his
are.
bank account to this bank account. They can't be connected in that way. So you're just wholeheartedly.
It's the landlord's
putting
bank
in-
account.
Right, but we don't even have witnesses that
Okay.
that's the
So
landlord.
the landlord's bank account.
Correct. There's nothing in the bank account except for the deposits of $2,750 that are corresponding to the defendant's lease. In the defendant's lease, it shows for Avenue Lofts condominium records, it shows,
All right, I got it. So there's the Dr. Shear and Mrs. Shear do not have a separate account that says lease of apartment in Fort Lauderdale.
no, it does not say that, no, Your Honor.
But the money that is coming in has the defendant's name on the check?
It's cash.
Oh, it's cash.
It's cash.
How is it attributed to the defendant?
Because that particular account only becomes into existence at the time that the defendant is signing the lease. And the amounts that are deposited every single month are the same amounts that the defendant has. And that's the only money that's in this account is
So
literally
they did create an account for purposes only.
specifically just for this apartment. But Your Honor asked who's going to testify. There's no one to testify to that.
How do we know this?
I got
We
your point.
don't know anything.
I understand your point. The Shears created a bank account.
Correct.
It has nothing on it like Scandirito or apartment or anything on the bank account records that indicate that that's what it's here for, set up for.
That's correct. However, the address of the bank account, who it belongs to, is DMS 16th Street LLC. In the defendant's bank records, there are transactions and checks initially, because he doesn't always pay in cash. Most of the time, towards the end of 2017, 2018, he does. But in the beginning, there is a transaction that goes from the defendant's bank account to Henry Shearer. And if we look at some of the records of the defendant, we do see DMS 16th Street that comes up.
So you have the defendant's bank records at some point in time where he's paying for this. So that's going to come in through the defendant's bank records, is it not?
He only pays a portion of the deposit from, because we can't track cash. So if he withdraws $2,800, which is the amount of his rent, and we don't see it again, and then we see a deposit in Diana Shearer's account for $2,800 that is connected to this DMS 16th Street Fort Lauderdale apartment, and we can link that to the Avenue Lofts Condominium Association records, which is the defendant's lease itself.
And your linkage is by circumstantial evidence. It's the same amount of money on the lease.
Correct.
Right? All right. You told me just a moment ago that some of the monies for the apartment were paid by check coming out of the defendant's account. Is that true?
That is true.
That is going to come in through the defendant's bank records.
It is.
Okay. All right. And I've already admitted over the defendant's objection is string of emails and communications with Dr. Shearer and Mrs. Shearer concerning his failure to pay March and the time and the circumstances surrounding the defendant's statements about when he would pay March and April, right? That's already in. Okay. I'm sustaining the defendant's objection. I find that the linkage between the cash deposits and the account is just, it's tenuous. It could be $2,800 from something else as well. Who knows? I don't know. But I'll allow the defendants, you can, if you want to show a history that the defendant had paid his rent and it was upwards of $2,700 a month, that's going to come in through the defendant's bank records where you show that he paid checks.
One or two.
Okay, fine, whatever. I mean, the bottom line here is that prior to March 2018, there's no evidence that he missed a payment.
That's correct.
And that's patently obvious.
Correct. And those records actually support that, but if we want to exclude them, I respect the court's ruling, that's fine.
Okay.
That was stated.
All right, I'm sustaining the defendant's objection to the bank records of Dr. and Mrs. Shearer. What else is there?
So we went through the Avenue Lofts records. The Chase credit card that the defendant has covers that time frame, so that's admissible according to Your Honor's ruling. States 148 Bank of America checking account for the defendant. States 149 is Bank of America summaries.
For the defendant?
For the defendant.
Okay.
Don Hughes is going to testify as a fact witness that the summaries that he personally created are from those bank records to make them more digestible for the jury.
Did you give notice under the rules that you had a summary witness for these complex financial records?
We did, Judge.
Okay, fine. All right, we're ready to go? Have I covered everything?
No.
What haven't I covered? I mean, I really, when I left here Friday, I sent an email. What else is there?
All these records have always existed.
Well, not with me. Not with me. I mean, when Carnifiello goes through detail by detail in an email, I'm able to then have an intelligent conversation with him and with the defense concerning those items. You didn't tell me about anything. Okay, what else is there?
Number 150 is the Northern Trust records. That's part of defense stipulations, and that was part of Your Honor's.
Who's Northern Trust records?
Northern Trust is the account that in defense.
Is it the defendant's financial records or?
It's not the defendant's financial records. It is a bank account that is opened upon death of his mother that is only accessible to the father, who is the victim in this case. It is the same account that the defendant lodges a forged check against.
Okay, I've admitted that. Yes, correct. What else?
There are Comcast bills, a packet of bills with a business record certification in just
for the Fort Lauderdale apartment or for the house?
Just the Fort Lauderdale apartment from January 2018 to March 2018.
And he pays them?
No, he does not.
Okay, all right. And And these are records from Comcast related to an account owned by the defendant.
Correct.
Okay, I'm admitting that. What else?
Strike records that are linked to the defendant's business of Leads to Closing LLC. Leads to Closing LLC will come up in the dad's records as well as the son records. We also have the Florida Division of Corporations public record certificate for that company, Leads to Closing, that is registered.
Leads to closing.
Leads to Closing.
It's a corporation formed by whom?
James Scandirito II.
And is the dad either an officer or stockholder in that?
Just the son.
Okay, so
And
just
what-
the defendant.
It's the defendant.
And what is it going to show? The records of that corporation.
The records of the corporation aren't coming in. The strike records show that the defendant, post-death, uses one of Dad's Capital One records cards.
Right.
Uses what's called Stripe. It's almost like a Square account. It's a money account that money can transfer through, and it takes a fee off of the top. On March 29th, the defendant uses that Stripe account to be able to transfer money from his father's account into his own.
All right, I'm admitting that.
Okay.
All right. But he puts it in
It goes through Stripe LLC, and it flags it as Leads to Closing LLC, which is attributed to the defendant.
And he's the sole officer in this other corporation.
Yes,
Right.
yes, according to that record, yes.
All right, I'll admit that.
We also have a business record certification for the Comcast IP address for
I
the...
just admitted that, yes.
No, IP address. Different records.
Okay, what's this up?
The Comcast IP address is just one set of records that shows that the defendant, or that shows, I believe, at Dad's house. It's a certified business record of the father's home that when the defendant, basically when the defendant is using some of his accounts through Bank of America, that the IP address associated with the usage on March 28th of 2018 and April 2nd of 2018 are registered to the victim in this case. It's just location information. It just says when somebody's using this transaction, this IP address is the location of that IP. So the IP address will give you a series of numbers. And in order to attribute that series of numbers to an address, they have to decipher it for you. So in this particular case, on March 28th of 2018 and April 2nd of 2018, that IP address is associated with the victim in this case. To what Ms. Victoria Spivey testified to. She's already testified to it, it just didn't come into evidence. But it has a business record certification. The state's position is it's actually already been made relevant. We don't even need someone to testify to it. We can enter it into evidence.
All right. I'm going to admit that. What else is there?
Okay.
Are we done? Listen, I've got a jury back here.
I understand you.
Ms. Walters, you got your one last thing. You should have told me about this before we came to court today. I mean, I understand where you were, if part of the L is taking the time, and based on my email, to go through exactly what is it, you should have jumped on and said, hey, look, this is what else I got. I mean, nothing.
I emailed it to defense, and
What about me? Nothing. Zip, nada,
They
zilch.
haven't lodged any objections, and that email was about
Well, you just know, but you just told me they're going to object to everything.
I'm only assuming that they are, so I'm addressing
I don't
it now.
know. Did you ask them, hey, do you object to all this?
I said in response to your Honor's email, because I
Did you ask them if they object to any of this?
implicitly, yes.
What does implicitly mean? I mean, you just asked the question, hey, look. All right, I'll just handle it on an objection by objection basis. So let's get our jurors in. Let's go. Thank you.
Deputy Andrews, line up, please.